Good morning, and may it please the court. My name is Elisa Smith, and I represent Juvenile SMM. The questions before the court today are ones of first impression in the state of Florida, but they are not ones of first impression in the country. I recognize that all jurisdictions outside the state of Florida and federal courts, particularly bankruptcy courts that have addressed these issues, have admitted the Kelley Blue Book as a market report over hearsay objection. And I feel a little bit like Don Quixote, but I'm going to ask that the court not follow that precedent for two reasons. And before I address those two reasons, I'll discuss a little bit of the facts of this case. This is a restitution hearing. It is restitution for an unrecovered car. The trial court valued the car, I believe it was at a little over $8,000, utilizing the Kelley Blue Book. The prosecutor below requested that the trial court take judicial notice of the Kelley Blue Book and its value generally of a Kia 2010 at 30 to 40,000 miles. At the hearing itself, the defense lawyer objected to judicial notice, and the defense lawyer also objected on hearsay grounds. The trial court, to some extent, did take judicial notice of the Kelley Blue Book, but the trial judge below also, over hearsay objection, found that the Kelley Blue Book would be admissible as a market report for that exception, which is subsection 17 of the evidentiary rules.
And the amount of restitution is, I think, the precise amount of one of the categories that apparently appeared on the screen.
Yes, what happened was the victim of the grand theft testified at this proceeding, and with the Kelley Blue Book internet site open, logged in the relevant information about year, mileage, condition, and those sorts of things. And that was used to value the car for purposes of restitution. The two reasons that I think this court should not...
Let me ask you this.
Okay.
The defense had prior notice that the state was going to do this, didn't they?
Yes, they did. And
so what expert or what other evidence did the defense put on to contest the Kelley Blue Book valuation?
Well, they filed an objection to the use under judicial notice, citing to this court's decision in Wallen-Taconis, I'm guessing is the pronunciation, and they did not provide any expert witness. They did object. It is the state's burden to provide competent evidence, competent and substantial evidence of the restitution value at a restitution hearing. And so it's our position that it was up to the prosecutor below to provide that expert witness. And that is our second argument, that if this court finds that the Kelley Blue Book can be judicially noticed, or it does qualify as a market report, and I am in no way conceding that point, that it is not a standalone document. In other words, it needs to be applied and interpreted. It's unlike corporate stock, which has been found to be a market report. And the trial court below actually analogized this to corporate stock.
Since the car was gone and never recovered, how is this ever going to get any better? It's not like the state could send out an expert to survey the car and get photographs of its condition and actually have someone do an appraisal of the car based on having examined the car and driven it and gone over it and all that stuff. So what could the state have done that was be any better than what they did?
Well, I think the state could have called, they have a litany of possibilities in terms of experts, unlike the case that was cited in supplemental authority, the Phillips case, that says it's nearly impossible to value certain types of jewelry. In this particular instance, we're dealing with a car. And there are tons of, not tons, but there's quite a few experts that they could call from the auto industry, used car dealers, a mechanic.
They call a used car dealer with 20 years of experience as their expert witness, and pay them expert witness fees and all that. And he comes in and says it's worth $9,000. And then the next question is why? And he says, well, I looked it up on Kelley Blue Book, and it says this. And you can't object to that, because as soon as he says that people in my industry rely upon the Black Book and the Blue Book to come up with a number, and I didn't rely exclusively on this. I relied on a couple other things, but my number is based on Kelley Blue Book. His testimony is completely admissible.
I would argue it is at that point, Your Honor. I think at that point there's a witness that can be cross-examined, and the witness could be cross-examined on the foundation, whether Kelley Blue Book is in fact used as this kind of reliable, accurate source. And that's one of my concerns, is that...
But he can't be examined as to the numbers that he starts with out of Kelley Blue Book.
No, not that he starts with. And I think that also leads, I guess I'm bouncing between my two arguments, but that leads to further support for my second argument that even if this is admissible, that it standing alone, unlike corporate stock values, is insufficient. It's a starting point. And many of the federal courts have struggled.
Which is exactly what happened here, is it started with the Kelley Blue Book website for that particular car, and then the owner of the vehicle, who is entitled to testify as to condition and use of the vehicle and so forth, plugs in the factors for which she testified, or on which she testified, as far as adjustments that needed to be made, and she was subject to cross-examination on those things. An expert would have done exactly the same, with one exception. The expert would have been relying on what the victim told the expert as far as all these adjustment factors.
Yes, and my answer, I guess, is twofold. One, the Kelley Blue Book is a starting point, and even if you look at the Kelley Blue Book legal disclaimer on that website, it says its value is simply an opinion, that it's not responsible for accuracy, errors, omissions, and the like. And
it is recognized, as the trial court indicated, it is recognized as an authoritative source of information for valuation by those who use it in the field.
And I guess my first argument is questioning that presumption. On this record, there's no proof that this is in fact...
challenge to that?
I believe that it was challenged in terms of the judicial notice, that in the objection filed by the juvenile's attorney, that they said under Walling-Taconis that this is not the kind of a source that is not subject to attack or variation. And I guess reaching that second component is that an expert would do a lot more than that. So even if this is a market report, and again, I'm not conceding that, particularly on this record, where there is no one who comes in and testifies that...
One of the cases that you cited for supplemental authority was the case involving the eForce database.
Hardy.
And the court there draws a distinction between the eForce database and says, in this respect, the database is unlike a book that compiles used car values or a newspaper that lists stock quotations. Any suggestion on what they might have been referring to as far as a book that compiles used car values?
Well, probably Kelley Blue Book, and I'm the one who supplemented that authority. But if you look at that sentence, it is dicta. First of all, it's using an analogy, and there is no citation to it. And this is a case of first impression in the state of Florida, and I am recognizing that outside the state of Florida, they have held this to be admissible. My problem with all of those cases is that there is no analysis that demonstrates this is in fact used by the auto industry. It's a presumption, that they're utilizing a presumption that this is utilized.
Is this, in terms of whether it's evidence of a market set value, is it relevant evidence that would be admissible as a factor in which to determine the value of the car?
Yes, a factor. And I do think that there needs to be an expert.
That's following up on that a little bit.
Yeah.
This is a case where the method by which it was put on was they put the owner on the stand and she explained how much she paid for the car and how she had used the car and how many miles were on the car and that it had Sirius radio and this and that and the other thing. And then they actually had her, from what I can see, look this stuff up on the computer in the courtroom.
Yes.
If they had followed up with one more question, which is, do you have an estimate of the value of your car? And she said, yes, I think it's $8,500, and I based that in part on my research on Kelley Blue Book. Would her opinion as the owner have been admissible?
I would argue no. Under this court's precedent in GMH and Fitzgerald, this is much like any other internet-based source. I think in the GMH case, they searched for the value of dirt bike parts, and in GMH it was catalog pricing. And I think it's very akin to that. You know, I think that this Kelley Blue Book is distinguishable from stock prices. Corporate stock is a stock and it's one value. It may be an opinion, but it's one value. And whether I'm purchasing it or Judge Silberman's purchasing it or you know, someone in Alaska's purchasing it, it's all the same. With cars, as this court recognized in Wollontokinus, that it varies substantially from car to car to car.
Let me ask you this then. Couldn't you take the position that the trial court actually did the defense a favor with this ruling? Because if all the state has is the Kelley Blue Book and nothing more, with all the problems that you've ably outlined that are associated with it, then the defense can bring in a live car guy who's an expert, and he can testify based on his knowledge, and then certainly the trial judge is going to give more weight to the live testimony than they are to something that just comes off the internet. So hasn't the defense actually benefited from this ruling? Because then they've got the ability to bring in their own expert who will be entitled to more credence than something that's just off the internet.
Perhaps. Two concerns with that, though, is that it sounds a little like burden shifting, that the state no longer has to establish by competent substantial evidence the value of this stolen and unrecovered car. And two, what happens if that scenario is that the judge says, well, I find that the expert's not credible, and I'm taking judicial notice of the Kelley Blue Book, and I find that to be a credible source, and we'd still be in this same position. I think the Kelley Blue Book, the analogy I'd like to make is with the Diagnostic and Statistical Manual for Mental Disorders that is regularly used by psychologists. I think the Kelley Blue Book is much like the DSM, and that is it provides a list, it provides categories, it provides descriptions, and it would be very surprising, at least to me, if the court were permitted to allow a non-expert to come in and rely on that commercial publication, admit it as evidence, have the trial judge review it, and make a determination for purposes of say, competency. And say, based upon the DSM, which I'm admitting, and I'm finding that that is something that is regularly used, and it is, and that they could make their own analysis.
Are practical factors something that we should take into consideration here in assessing this problem? Because, I mean, for the most part, as someone who's had to do this stuff, I've found that trying to bring in somebody to value a car is generally not cost effective unless you're talking about a Bentley or a Maserati or a Lamborghini or something like that. And if it's a garden variety Chevy or Kia or whatever, it's going to cost you several $100s to get an expert to look at it, come in and testify, sit around and wait, and it's just not worth it. It's not cost effective.
Well, I mean, I don't think due process varies depending on how much money you have, and I'm sure someone in that situation would have a private lawyer, and someone whose car is stolen is still worth a value, whether they have a Bentley or they have a Kia Rio. So I would think that due process for both the victim and the defendant wouldn't vary based upon the value. And I don't know that it would be that costly to have an expert, a mechanic or a used car dealer or someone come in and testify, because there is more that goes into this valuation than what Kelley Blue Book provides.
You're saying that the state has the initial burden of going out and spending, whether it's several hundred or $1,000 or whatever it's going to be, to have someone testify as to the value of a car that ultimately is worth $8,600. Does that make any sense in the real world?
It may not, but
Most get passed on to your client.
They could be passed on, I guess, to the defendant, but the law isn't always practical. But it has to provide due process and fair hearing and not burden shift to the defendant.
Doesn't the client get due process if they can bring somebody in to counter the internet valuation?
Well, not if it wasn't admissible to begin with. And our argument is that it's the state's burden to show that there is competent evidence and that this valuation is competent accurate, admissible, reliable, and all of those things, and they have failed to do so here.
If a judge makes a finding, as this court did, that the document is reliable, that the document is customarily used and is often used and is accepted within the community, doesn't there have to be some showing by the defendant or some evidence or at least some argument based on fact that in fact, Judge, your understanding is incorrect, that it is not accepted in the community and here's why?
Well, in Wallentokus, the dicta would indicate that it is not that kind of a report. I mean, I know that these are two different analyses. You know, one is for judicial notice and one is for the exception to the hearsay rule, but they do intersect quite a bit in terms of the type of report this is and how it's admissible. In that particular case, even though it's factually distinguishable, and I recognize that, the court did find that this was not the kind of book that could be relied upon for the language. I wrote it down, but I can't find it right now. That it is readily acceptable. So you look at the figure, and that's the figure, much like corporate stock. This is more like the DSM, where the value is going to vary depending on car to car, whether it's the type of radio, the type of tires, all these other things that an expert could evaluate, much like the DSM that's evaluating individuals who are like automobiles in that they are all different, that there is not one size fits all. And because there's not a one size fits all, that burden is on the state to establish what that amount of restitution is.
Well, harmful, harmless error standpoint, and this is one for a change where you have to prove it's harmful, not harmless. The state doesn't have to prove it's harmless. I'm struggling a little bit with the reality that the victim can sue your client and get a summary judgment on civil theft and get treble damages and attorney's fees for this same matter. And from the standpoint of was there harmful error in the restitution hearing, I'm still uncertain.
An issue that wasn't briefed. I guess as a cursory matter, if the court allows this type of evidence to come in, then there almost becomes no point in having a restitution hearing, because it'll always be harmless, because you're always going to get triple in civil court. And I'm not a civil lawyer and I never have been, but if you can always get triple the value, then it would always, under that scenario, be harmless, because you're always getting, no matter what the figures, you'd always be able to get more in civil court. And I think from a legal perspective, and perhaps not a practical one, that the evidentiary principle here is an important one. And it's, whether the state, and I think there probably needs to be a written decision on this because it is first impression.
All right, I've let you run over.
Yes.
But let's hear from the state at this point in time. Ms. Dunlevy?
Thank you.
Police Court. I represent the state, as Judge Altenberg noted, and I asked for oral argument in this case, partly because I know the court wants us to ask for oral argument more often, and partly because I think this is an issue that is likely to recur. And I don't think that in a case such as this, where the car that was stolen was never recovered, that taxpayers' money should be expended to call in an expert to testify to something we all know, and that is everybody who knows anything about cars, even people who just drive them like me, has heard of the Kelley Blue Book, and when occasion arises, they go to the Kelley Blue Book or possibly to the NADA for information on the value.
But every time I try to trade in my car, the used car salesman tells me that that valuation's too high and he wants to give me a lower one. There's about a degree of horse trading that goes on in cars that doesn't go on in bushels of corn or shares of IBM, right?
Yes, Your Honor. In fact, I think they have two separate values, one for a trade-in value and one for somebody who wants to sell a car or somebody who wants to go to a private party and buy one. And it is not, the state is not taking the position that the Kelley Blue Book is the absolute be-all and end-all here. The state's position
The
is
trial
that
judge himself took the position that this was, he was admitting it, taking judicial notice of it as a market report.
Yes, Your Honor.
And at least that reasoning concerns me.
I'm not sure what aspect of the reasoning you're
Well,
concerned with.
his award is dollar for dollar what was in that market report, when, as you just indicated, that this is an area where there are ranges, not where there's a precise number.
Well, first of all, when we're talking about a Kelley Blue Book value and the NADA as well, there are variables that are accounted for, and if you use the website, you indicate what the car's mileage is, what the car's condition is, what various features and accessories the car has or does not have. All that goes into, and then there's also, you have to pick a category that ranges from, I think, excellent to very good to fair, to take into account the general condition of the car. And so the victim here said, I think my car was in very good condition. And the judge said, no, I disagree, I'm going to find that it's in good condition. The defense, the only complaint they had was that they wanted the state to bring in an expert. And while I think that it would be a reasonable argument in a case where the vehicle was recovered so that an expert could examine the vehicle and make their own expert determination of the condition of the car, rather than having to rely on the lay victim who might not recognize the seriousness of what appears to be a minor scratch, might not fully appreciate the condition of the tires, things like that. But this defendant chose to make that impossible by disposing of the vehicle so that it could not be found. And all we had was the victim, and she was familiar with her car, at least as familiar as most ordinary car owners are. And as has been pointed out by maybe all three of your honors, the state puts on their evidence. That does not preclude the defense from putting on their own evidence to counter the state's evidence. They could call
that's true, but it's very hard to cross-examine the computer in the courtroom. I mean,
sure, they could just go to the NADA.
Cross-examine Kelley Blue Book in the internet. I mean,
no, you can't cross-examine, but it's a market report. You can't cross-examine it. You can't
they
counter
have
it.
to bring in their own expert to counter your online computer.
Oh, they could bring in another online recognized, like the NADA, which is also.
We're going to spend 2 hours in the courtroom now with Google searches to find out what cars are worth at restitution hearings.
Well, maybe not quite that long, but well, the other option is, the parties can get together and see if they can arrive at a reasonable amount and stipulate to it. That did not happen in this case.
One of the things we talked about earlier is expert witnesses who might or might not rely on the Blue Book, but it would also be possible for the state to have brought in a live individual to testify, not based on Blue Book or any other market compilation, but based on, I don't remember what this vehicle is. If it's a Ford, I work at a Ford dealership. We handle used cars. We've had this type of car. Here's what it has sold for. And it also has to be adjusted based on the known factors that the victim has testified to regarding condition and so forth. And then you have a live person who can be testified, can be cross-examined. as to the basis of his or her testimony on valuation, on the cars that went through his or her lot and so forth. And I'm not certain that this burden is that great on the state to call a live witness to be subject to cross-examination on these issues.
Well, a couple responses. Number one, the victim was subject to cross-examination concerning all the characteristics of the vehicle. Number two, calling a single car dealer who buys, and typically new car dealers will take other models in trade. How many used Kia Rio XLs or Kia Rio anythings that particular dealer has dealt with is probably an extremely small number.
We don't know that because there was no expert to testify to get cross-examined with those kinds of questions.
That's true, Your Honor, and it's the state's position.
And we also don't know, based on the record before us, how Kelley comes up with its valuations, whether they tend to be artificially high because they're in the business of I think it was owned by Auto Trader or whatever the other publication is. Or we don't know what their basis for valuation is.
You're correct, Your Honor, that we don't know exactly how they reach their valuation. If you're concerned that their values are high, there are other market reports available, and the defense in this case could certainly have said, we think the NADA is more reliable, and those are the two biggest names.
One of the things that the state doesn't seem to have argued extensively either in the trial court or now on appeal is whether the trial court correctly evaluated this Blue Book as authoritative, an authoritative compilation. Was there any suggestion that either it was or wasn't, or did everybody just rely on judge? We think it's a market compilation that's reliable. The judge says, oh yeah, I've heard of it, know about it, maybe even has used it. So whose burden is it to sort of support or bolster what the judge's view of this document is?
Well, I think the fact that we have virtually every other state in the union accepting the Blue Book and also the federal courts accepting the Kelley Blue Book is sufficient indicia that the trial court was correct.
Do you think the majority of states are allowing judges to pull this up on the internet in the courtroom and set values based on that? I didn't see that in the case law you cited.
I haven't seen any case law that specifically dealt with this, but to the extent that somebody could be faulted for using hearsay because they're looking at a book and how old is this book, if you go on the internet...
Nobody's arguing this was admissible under an exception to the hearsay rule. And Florida still doesn't have that exception for the otherwise generally reliable information that the federal courts have, to the best of my knowledge. So, I mean, can you argue that this comes in as admissible hearsay? Nobody
I think
can.
it comes under the 803 sub 17 exception for market reports.
But it's not a market report. Not in any normal sense. It's just not like a bushel of corn where we know on Tuesday it's worth $1.17. It just isn't that way.
Well, not in that sense, no, but I think it falls under that, and there was no argument below saying, oh, this isn't a market report. The only argument that the defense made was you need to the prosecutor should have to bring in a live expert to testify. And if the live expert is simply going to come in and say, I rely on the Kelley Blue Book, then it's a waste of everybody's time and the taxpayers' money to have to bring in an expert just to testify to that. If, as I indicated, there had been a car recovered that an expert could examine, then I would not say that necessarily the state shouldn't have to bring in an expert. I think it would depend on the circumstances. But here, where there's nothing for an expert to examine, and where it is general knowledge as manifested by, if nothing else, the case law, and you know, if you talk to your friends and neighbors, and I think most people have heard of the Kelley Blue Book. The Florida legislature has required use of the NADA, which is, I think, the Kelley Blue Book's main competitor, if you will.
The so-called Black Book.
To use that in lemon law cases.
Do we know in this case whether the Black Book and the Blue Book would have come up with the same number?
I don't know that, Your Honor, and my guess would be they would not be identical. And so I'm not arguing that this is not, that a Kelley Blue Book value
if
is
they're not
identical,
subject. They're not really market reports, are they? Because market reports for IBM stock, whether you look in Wall Street Journal or the New York Times, is going to come up with the same number.
Well, this isn't stock, Your Honor, and obviously, but I think it still qualifies as a market report.
Does Zillow apply as a market report then too?
Pardon?
Is Zillow going to apply as a market report for houses if everybody looks up house values now on Zillow?
Possibly.
Well, I mean, is it the problem that houses and cars, unlike shares of stock and bushels of corn, are not fungible? I mean, they're all different, have different characteristics.
I agree that they're not as fungible as bales of hay or bushels of corn, but nevertheless, when there's a situation when you have to determine the value of a motor vehicle, you have to have somewhere to start, and most people start with the NADA or the Kelley Blue Book, and you put in all the information so it's taken into account. And to the extent that the Kelley Blue Book doesn't take something into account, you can make a rough estimate as to how much you should raise or lower the value of the vehicle. The Kelley Blue Book, I'm not saying that it is not subject to dispute. I'm saying it is accepted as an authority by the public and by people in the professions that need to value used cars, and that it qualifies as a market report. Does not preclude the other side from bringing in an expert, does not preclude the other side from bringing in somebody else who knew the condition of the car before it disappeared, does not preclude use of a competing market report or used car valuation guide, but it is a market report, and it should be, the trial court should be able to take judicial notice of it under 90.202 subsection 11, which was the one subsection the prosecutor left out in his notice, but that it's known, I'll get the precise wording. Facts not subject to dispute because they're generally known within the territorial jurisdiction of the court. The fact being the Kelley Blue Book is a well-known and respected and relied upon source to determine the value of a used vehicle. That's the facts, that it's not really subject to dispute. And then and I don't know whether it's hearsay or not, because although the victim did testify before they did the thing with the computer that she had looked it up online herself and gotten a value, even though she mentioned that, that was not what the court relied on. The court relied on, they went to the source, directly to the source, the most up-to-date version of the source that anybody could go to, and that is the online website, and got the information directly from kvb.com rather than from somebody testifying to what the Kelley Blue Book value is. So I don't know whether that would be hearsay or not. It would depend on how does that information get there. And I'm guessing it's probably a combination of humans putting in updated information and computer algorithms calculating permutations. So I don't know, but it doesn't, as far as the state's concerned, it doesn't really matter, because if it's hearsay, it falls under a market report.
Okay. All right, thank you.
Other questions? Then I'll just
Here,
ask
Ms. Smith.
the court to affirm and join in opposing counsel's request that this court write an opinion if you're so inclined. Thank you.
Just briefly, the trial court below actually made a finding that the NADA book and the Kelley Blue Book merged. So I don't believe there are two separate books out there. I don't know the black book, and that wasn't referenced below. But on page 174 of volume 4, the trial court judge made that finding, so perhaps they did a search and found that they had merged. So there is no alternative through NADA. And I think that opposing counsel, when she argues that it is subject to dispute, is almost conceding an argument that I'm making, and that is you need to have an expert. The victim is not qualified. She has no idea, just like I have no idea what goes into developing the Kelley Blue Book. There needs to be someone who has some knowledge about value, even defining things like what is good, what is fair. You know, there needs to be someone other than a victim who says, I think my car is in great condition. That kind of a thing. And finally, I'm sorry.
Your client sort of made this car completely and totally disappear. So unless they happen to have a picture taken the day before he stole it,
He did.
This is kind of hard. And it seems to me the burden on that ought to be on him, shouldn't it, or her?
To the extent that the victim could be cross-examined about the quality of her car, I think that he was able to do that. I think it's a he. He was able to do that. But I think that that same information could be provided to an expert who would say, well, if there was this nick or that nick or these tires, that they can compute a value, and then that person could likewise be cross-examined as to how that either appreciates or depreciates the value of a car. But if this court allows this kind of a report to be utilized solely and exclusively for value, it really is opening up the door to allowing all kinds of internet-based searches for value to be used in all kinds of at least restitution hearings. And for that reason, we're asking that you find, one, that this does not qualify as a market report on this record, and two, alternatively, if it is a market report, that the trial judge abused his discretion by using it as the sole and exclusive value of measure for the stolen car. Thank you.